The phrase, "could it happen to you?" should always be on your mind when looking at any sort of legal issue where there's a lot of posturing like there is with the RIAA. Oh, we're going against the pirates. We're going against the big evil AI companies. And we're for the little guy. We're for the little artist. Consider how it might be turned against you. And I got a really personal lesson on this back after Judge Kaplan's decision in Universal v. Corley, where I wrote the protest song that demonstrated quite clearly that code was free speech. And I was kicked off of mp3.com and my song was banned, despite the fact that I wasn't a party to it. I don't even live anywhere near the Southern District of New York. And yet, somehow, that one district court ruling meant that I couldn't say what I wanted to say in the way I wanted to say it. Now, in reality, the Streisand effect kicked in, and then people started posting the computer code hoedown and so many more things that people were doing, because I was far from the only one, on all sorts of different websites. And you can probably still find it out there if you wanted to, but the point is that's what they do. They make out like they're going after these big bad corporations or these terrible hackers or these horrible pirates. They're really coming for you. And that's what we're going to see here in part 3 of our coverage of Yout v. RIAA. At this point, you've got an idea of what the case is about. And at this point, you've heard from the RIAA and the Copyright Alliance about what they really want. So let's bring it home with Yout's reply brief, and we're also going to tie it into the AI cases by looking at Suno and Udio's Amicus brief. So we'll start here over on page 6. It will be understandable if, after reading the RIAA's answer brief, the court found itself perplexed about the procedural stage at which the underlying litigation was dismissed by the district court. This case does not come before this court following a trial during which the parties presented competing expert witnesses and a fully developed factual record. Nor does it come after a motion for summary judgment with the benefit of full discovery and deposition testimony and documentary evidence. Indeed, this case does not even come before this court following an evidentiary hearing and the grant of a preliminary injunction. Given the RIAA's arguments, which rely heavily on unsupported assertions dressed up as facts, facts which appear nowhere within the four corners of the complaint, inferences which impermissibly favor the defendant, and disputed mixed questions of fact and law, it will be easy to forget that this case actually comes before this court following the district court's allowance of a Rule 12b-6 motion to dismiss, a decision that should have been, but which was not, limited to the four corners of Yout's complaint. In an answering brief that is equally notable for what it does not say as what it does, the RIAA attempts to argue not only that it's entitled to rely on technology that it claims to have been put in place by YouTube, but that it makes no difference at all whether YouTube intended for the technology to limit the access to or the ability to copy the videos that are freely available on YouTube to anyone with an internet connection and a browser. And while this is a remarkable position at odds with the case law of this circuit and elsewhere, it is presumably the only position the RIAA can take, given that YouTube has neither come to the RIAA's aid as an amicus, nor have the parties had the opportunity to take discovery from YouTube, or any discovery for that matter. So we don't actually know any facts, and this case has been going on for over 3 years. If it were so gall-darn important to YouTube, wouldn't they have come in as an amicus? We're going to see in a minute how quickly Suno and Udio were able to come in and file an amicus brief. Surely YouTube could have done this by now if they were so concerned about this. The district court erroneously concluded that Yout's software platform was a circumvention tool under 17 U.S.C. section 1201, a conclusion that it could not possibly have reached at this early stage in the litigation, necessitating reversal. Admittedly, it is somewhat rare that in a reply brief, appellant would feel the need to reiterate for the court the procedural posture from which the appeal was taken. Then again, it is also somewhat rare that, in its answering brief, an appellee would almost exclusively cite cases where the underlying litigation had been decided at a much later stage of the proceedings. And yet, such is the case here. The RIAA relies most heavily on this court's decision in Corley and the district court's decision in Ramirez. That case, however, in addition to being easily distinguishable, was decided only after a full bench trial in which the court heard from and weighed the testimony of the parties' witnesses, competing expert witnesses, and documentary evidence, not to mention the completion of full discovery which allowed the parties to present such evidence at trial, with a whole lot of corruption by Judge Kaplan. I mean, at the time, someone managed to get a transcript and post it, and oh my god. So there's probably still copies of the transcripts around if you wanted to read it. It's corruption on the level of the Martha Stewart trial. Or the William Penn trial, really. Other cases cited by the RIAA were similarly decided on summary judgment after the parties had the opportunity to fully develop the factual record through discovery. It is not an accident that each of these cases was decided at a much later stage of the proceedings. As discussed in Yout's opening brief, and is evident even in reading the RIAA's answering brief, the issues at play in this case are complex, involve highly technical questions that are either entirely factual or are mixed questions of fact and law, and which, in either case, require expert testimony, and which can only be resolved by a fact finder after the parties have had the opportunity to conduct full discovery. Ironically, the only one the RIAA cited that was decided at the motion to dismiss stage supports Yout's arguments, and that's Hatler v. Ashton. The RIAA claims that Ashton rejected the argument that because works were publicly available for streaming, the door to the works was open, but the RIAA's reading of Ashton is illustrative of the fallacy of the RIAA's repeated attempts to claim that there is no difference between the access control provisions of Section 1201 and the copy control provisions of that section. To the contrary, after citing with approval this court's decision in Corley and its discussion of the distinctions as between the two types of anti-circumvention provisions, the Ashton court specifically concluded that even though the defendants there admitted that they had circumvented technology expressly designed to prevent the copying of the works, something which Yout denies in this case, there was no violation of Section 1201A1. And that's what this is about, that all-important distinction between access controls and copy controls. The RIAA relies on the way in which YouTube appears to operate in its assumption of both the existence of a technological measure and the purpose of the technology at play. That the RIAA must resort to these factual assumptions, as the district court did below as well, simply proves that the present case is not susceptible to a Rule 12b-6 motion to dismiss. There is no evidence before the court, nor was the district court presented with any from YouTube itself concerning either the specifics of the technology employed or the purpose of such technology. The RIAA's assertion that the relationship between its members and YouTube are the cornerstone of the digital music economy and the sky is falling insistence of its Amicus that a reversal of the district court's order would eviscerate the protections afforded by Section 1201 and would harm and undermine popular methods of disseminating the speech of copyright owners. One might have assumed that YouTube itself would have appeared on appellant's behalf as an amicus. That it did not leaves an elephant-sized hole in the room. The RIAA attempts to cover this enormous hole with fig leaves, astonishingly arguing that the purpose of the technology employed by YouTube is irrelevant and should simply be ignored by the court as it was by the district court. Oddly citing the court's decision in Ramirez for the proposition that what matters is whether the function of the technological measure is to control access. That would be a question of fact, right? The RIAA seems to misapprehend the plain meaning of the word function. According to the dictionary, function is the action for which a person or thing is specially fitted or used or for which a thing exists. Purpose. The RIAA's own citation then demonstrates that the purpose of the technology employed is indeed crucial. The RIAA then pivots, arguing that YouTube's intent in utilizing technology is irrelevant because Section 1201 is supposedly silent as to intent. This assertion is incorrect and defies common sense. A plain reading of the statute confirms this position. Had Congress wanted 1201 to be intent-free, as RIAA asserts, it could have easily said that no person shall circumvent technology that effectively controls access to a work protected under this title. It did not. Instead, Section 1201 regulates the circumvention of a technological measure that effectively controls access to a work protected under this title. Again, since the statute does not define a measure, we go to the dictionary, which defines measure as a step planned or taken as a means to an end. The court recognized this in Corley, holding that the focus of subsection 1201A2 is a circumvention of technologies designed to prevent access to a work, and the focus of subsection 1201B1 is a circumvention of technologies designed to permit access to a work but prevent copying of the work or some other act that infringes a copyright. In fact, that's exactly how they were able to completely invalidate fair use and set up this catch-22. Oh, you can copy it and that's fair use, but you can't access it in order to copy it, in order to exercise fair use. Numerous other courts have similarly referenced the statute's clear requirement that the technology employed be designed or intended to restrict access or copying. Page 17 for those trying to keep up. Finally, the RIAA asserts that YouTube's intent can be inferred from their terms of service, of which the RIAA asserts the district court properly took judicial notice because they were part of the pleadings. Putting aside the fact that such an inference in the RIAA's favor would be improper at the motion to dismiss stage, the operative complaint does not reference YouTube's terms of service, but rather it references Yout's terms of service and facts. The RIAA cites extensively to this court's opinion in Corley. Indeed, given that the Corley decision is the only substantive Second Circuit Court of Appeals decision concerning the anti-circumvention provisions of the DMCA cited by the RIAA, it's worth unpacking in some detail. Corley is so factually dissimilar from the present case that it could serve as an issue spotting exam for law students learning to distinguish cases. Corley came to the court following full discovery and a bench trial in which the parties were able to present witnesses, expert testimony, and documentary evidence to support their respective positions. Which in the MPAA's case, if you remember, was that you should not be allowed to make a DVD player on Linux. They couldn't just control the copyright of the movies themselves, they had to say which players you could play it on. That's what it was, remember that. Armed with this fully developed record, the district court and this court were able to make the necessary factual findings and rulings of law. None of that has occurred here. The Corley plaintiffs were 8 major motion picture studios, basically the MPAA. As it was then, it's the MPA now. They dropped the of America, who brought suit against Eric Corley and his company, 2600 Enterprises. They're a magazine company. They publish a quarterly computer magazine, alleging violation of the anti-circumvention provisions of the DMCA. They were brought in because they wrote a magazine article about that attempt to write a Linux DVD player and publish some of the code for it. Clearly free speech, clearly free press, clearly protected by the First Amendment, only able to be decided because they said computer code wasn't free speech. In Corley, the evidence demonstrated that the rights holders actually created a technological measure, an encryption algorithm, and a sucky one at that. Just to let you know, if you're not familiar, it was cracked by a 15-year-old Swedish kid. With the specific intent that this algorithm would effectively control both access to the copyrighted works and the ability to copy those works. In other words, DRM. And that's the only reason DRM has any force today, is that court case. In providing their works to YouTube, RIAA's members have chosen not to incorporate DRM. The inclusion of such tools would render any video protected by such a tool incapable of download by Yout. Here, too, it is worth pausing to note what should be an obvious material distinction between Corley and the present case. Indeed, it is a material distinction between the present case and almost every case cited by the RIAA. In Corley, the DVD movie was not made freely available to the general public. You had to purchase a DVD, drastically limiting access to the copyrighted works. Defendant's website, 2600.com, and the print magazine 2600 Hacker Quarterly focused on the vulnerability of computer security systems and more specifically how to exploit that vulnerability in order to circumvent the security systems. In 1999, a Norwegian kid, I think I might have said he was Swedish, he was Norwegian, created software to decrypt CSS called DCSS. The Corley defendants wrote an article about it, published it in their magazine. It explained that it also could be used to copy DVDs as well as play them because they're basically the same thing. You gotta decrypt it either way, which means you have to give people the decryption keys to do it because there's no other way to play it. That's why all forms of DRM are doomed to fail. And since they can't support it technologically, they have to try and support it legally, which smashes the First Amendment to pieces. At the end of the article, they posted copies of the object and source code, and also linked to other articles and websites where DCSS could be found. Corley testified at trial that he published the code because he thought it was incumbent on him to show his readers the evidence that there is in fact technology that circumvents CSS. Wow, publishing your evidence, that's like actual journalism. Wow, you don't see that much these days. Hundreds of websites posted the DCSS code. The studios responded with cease and desist letters, but some websites, including the Corley defendants, refused to take it down, resulting in the litigation. Following a full trial on the merits, the trial court found that Corley defendants' publication violated the anti-trafficking provisions of the DMCA, issuing a permanent injunction against the Corley defendants. The studios had developed and implemented a technological measure with the specific intent that such encryption would block both access and copying. In addition, the studios licensed to DVD player manufacturers the specific technological key necessary for those players to access and play the copyrighted works. Without this key, users cannot access the copyrighted works. And that's how they were able to limit not only the copyright of their movies, but how you could play them, which specific players. You couldn't just make a DVD player on your own. What do you think this is, capitalism or something? And the studios only agreed to provide such licenses to DVD manufacturers who agreed to manufacture their players in such a manner that the players could not copy or save the copyrighted works to a hard drive. And of course, the movies at issue in Corley were not freely provided to the entire world, like they are on YouTube, but rather were sold to customers only on DVDs that incorporated this CSS encryption. The Corley defendants knowingly provided access to a technology with a singular purpose, breaking encryption on the DVDs containing the studio's copyrighted works. The present case could not be more dissimilar. There's been no development of any factual record. The RIAA's members have not put themselves in place any technology designed to prevent either the access or copying of their content. Instead, they have agreed to allow their content to be broadcast to the entire world, because that's how YouTube works. The RIAA only claims to rely on technology allegedly employed by YouTube for reasons which may have nothing to do with the prevention of access or copying at all. And in a footnote, the RIAA claims that RIAA members authorize online streaming services such as Google's YouTube to stream their copyrighted works. In return, Google shares revenue it earns from advertising or subscriptions and protects their copyrighted sound recordings from unauthorized access and copying. No part of this factual statement, however, can be considered by the court because none of these alleged facts are contained within the four corners of the complaint. Additionally, this assertion runs counter to statements the RIAA has frequently made in the public press, because they're lying sacks of shit. Finally, we're getting close to the end here. Without any factual basis, the RIAA repeatedly asserts that the Yout.com website has no purpose but to allow users to infringe upon its members' copyrighted works, and that it is specifically marketed as serving that purpose. To paraphrase one of the members' recording artists, "You're so vain, I bet you think this software is about you." I mean, as if the RIAA's music is the whole of everything you can get on YouTube. The service provided by Yout is content neutral, providing nothing more than a recording device that utilizes the very information that is freely and publicly available to anyone who cares to look for it, without the need to circumvent anything. As Yout and its amici have all pointed out, the service has significant commercial uses other than to circumvent protections afforded by a technical measure that effectively protects the rights of a copyright owner. To the extent that the RIAA thinks otherwise, it should have the opportunity to prove that theory at a trial following discovery. Put your money where your mouth is, RIAA, instead of taking shortcuts because you got the fix-in with crooked judges. Which is what they've always done anyway, so that was 2.5 years ago. And so this case has been plodding along at a snail's pace since then. But exactly 1 month ago as I record this, we have the Amicus brief from Suno and Udio, which goes over all of the problems with it that we're seeing in so many cases this year. Section 1201 governs the circumvention of technological measures. Courts have held that Congress did not directly provide for a fair use defense to claims brought under Section 1201, notwithstanding serious concerns about how the new prohibition could frustrate fair uses. Instead, on this view, Congress harmonized Section 1201 with fair use by drawing a careful distinction between two different kinds of technological protection mechanisms, access controls and copy controls, and drafting a statute that prohibited circumvention only of the former, not of the latter. That question has significant implications outside this case for parties who, unlike Yout, do not traffic in any tool or offer a service to circumvent such a mechanism, but instead circumvent it themselves. If YouTube's download prevention mechanism is a copy control, that act of circumvention is perfectly lawful. If it is an access control, that act of circumvention is presumptively unlawful. That asymmetry was intentional. Congress enacted it specifically to protect fair users. Copy controls, by definition, protect the rights of a copyright owner, including by preventing unauthorized reproduction of copyrighted works, but not all reproductions are prohibited by law. Any individual may reproduce a copyrighted work for a fair use. The copyright owner does not possess the exclusive right to such a use. And that goes all the way back to Sony v. Universal, and that's exactly what they want to go against. Just look online. See what all the propagandists are saying. Oh no, they can only do fair use if they license it. They should have licensed it. If they licensed it, they can do all the fair use. Not how fair use works. Not how fair use works. If the use is fair, you have the right to copy it. Without permission, without authorization, without license. Enacting a statute that would penalize circumvention of copy controls would, in effect, give copyright owners the de facto right to prohibit fair uses, which is exactly what they want. The ruling below jeopardizes this carefully calibrated statutory framework. The technological measure is designed for a single purpose, to protect works on YouTube from unauthorized copying and downloading. That makes it a copy control, not an access control. The court below did not appreciate the importance of the access control copy control distinction or the fact that the statute treats them differently to protect fair uses. Instead, the court declined to consider the copy control provision at all on procedural grounds and erroneously concluded that YouTube's download prevention mechanism was an access control without ever considering whether it is more appropriately characterized as a copy control. That was an error with serious implications. It suggests that anyone who downloads a YouTube video, not only AI startups, but documentary filmmakers, teachers, and the like, is liable for statutory penalties under the DMCA, even if that person's activities fall squarely within the contours of fair use. You could hit fair use right in the bullseye, and you would still be subject to criminal liability, $500,000 and 5 years in prison for the first offense for exercising your right to fair use, which is your First Amendment right, your protected free speech. Copyright holders have already attempted to rely on the court's error to justify assertion of Section 1201 claims on the basis of unauthorized downloads of publicly accessible copyrighted works, and to argue that those claims should survive even if the defendant's use of those works is adjudicated to be fair use. This is precisely what Congress sought to avoid. To say that we don't care if it's fair use or not, you still broke the law. Which they're not supposed to be able to do because the First Amendment overrides it all. The quintessential access control is a password. The function of the password is to prevent anyone who lacks the authority from gaining access to the work. In so doing, the password controls access to the work. That's Section 1201A. Section 1201B addresses copy controls. They kick in after a user has gained access to a work. When proposals for an anti-circumvention bill first came before Congress in 1995, the bill initially prohibited tracking in devices designed to circumvent technological measures that inhibit the violation of any of the exclusive rights protected by copyright. Legacy media industries, including the RIAA, wanted to go even further and lobbied for a sweeping prohibition on the act of circumventing any technological measure designed to protect against copyright infringement. But technology industry representatives and others noted that a broad prohibition would impede legal copying. As one group explained, it is well established that the public in some instances may make copies of a work without infringing the copyright, including by making fair use of the content without the permission of the rights holder. Prohibiting circumvention of controls designed to preclude unauthorized reproductions would, in effect, prohibit activity that the fair use doctrine explicitly authorized. So Congress endorsed the compromise outlined above. And they immediately sought about going through court cases like Corley to undo that. Any copyright owner has the baseline right to decide when and how to make her work accessible to the public, whether to keep it under lock and key, whether to show it selectively, or whether to make it freely available. But once a copyright owner decides to make a work accessible to the public, the question whether someone can copy it depends not on the copyright owner's preference, but rather on the contours of the Copyright Act, including the doctrine of fair use. Making copy controls effectively impregnable by preventing their circumvention outright would have amounted to a strict legal prohibition on copying that fair use explicitly authorizes. Instead, Congress expressly disclaimed any intent to impair any person's rights of fair use. This is why the statute, as enacted, does not prohibit the circumvention of technological measures that do nothing to prevent access to the plain text of the work, but are designed to prevent that work from being copied. Of course, it did impair fair use things like playing your legally purchased DVDs on Linux. This is really something that needs to be corrected for. Ultimately, just repeal Section 1201 entirely is what needs to happen. Measures that control access to a work must prevent the public from viewing that content without the authority of the copyright owner. If, on the other hand, it does nothing to prevent access to the work, but is designed to protect the work from being copied, it's a copy control and not governed by the statute's access control provision. And the fact that it might accomplish that copy protection by controlling access to something other than the content of the work, e.g., a downloadable file containing that work, does not convert that measure into an access control. Here, neither party disputed that anyone with an internet connection can view the content of YouTube videos on the platform for free and without a login. And even the RIAA admitted in its pre-litigation notices that the singular purpose of YouTube's mechanism is to protect its members' works on YouTube from unauthorized copying and downloading. That means the download protection mechanism is a technology designed to permit access to a work, but prevent copying of the work. And because it is a technological measure that prevents copying, it is a copy control, and nothing in Section 1201 prevents its circumvention. While the district court's failure to analyze that was inadvertent, the reasoning of its opinion threatens to upend the statutory framework Congress enacted. That reasoning has already supplied the basis for assertions of Section 1201 claims against defendants like Amicus, who have done nothing more than download publicly accessible works to make fair uses of them. If endorsed by this court, That reasoning will no doubt lead to even more aggressive assertions of this statutory provision by copyright holders who seek to use it to curtail fair uses of their works. That, in turn, threatens to deprive the public of the benefit of these fair uses. This is the opposite of what Congress intended. This court should correct that error and give effect to the statute Congress enacted. And it'd be nice if that happens. I don't know what the Second Circuit is going to do, and I have no faith in the Supreme Court over this. All I know is we need to keep fighting, because remember, this is very much about you and me. This is about our free speech. People, including myself, and including potentially you, have been and will be censored because of 1201. In fact, if you keep talking about subjects like this, sooner or later, it's inevitable that you will be. This is an absolute violation of the First Amendment, and we should not be standing for it. So I hope you share this information and share this video, because that's how you get above the shadow banning. That's another tool they use. They've got all sorts of tools they use that have nothing to do with going into court. And also like and comment. And remember to subscribe and hit the bell so you'll always get notified whenever I post a new video. And of course, donate.pagosity.tv keeps me doing what I do, whether it's one-time donations or regular support. Whichever you choose, donating regularly, donating one time, or just sharing, any of that helps more than you know. So thank you very much for watching. Until next time, stay strong and be free.